Greetings and welcome to Troutman Pepper's Patent Post-Grant podcast series. My name's Andy Zappia and I'm joined today by my colleagues Mike Goldman and Megan O'Gara. And this podcast is part two of a three-part series we are doing on the use of reissue or reexamination in the context of inter-parties review or IPR proceedings or post-grant review, PGR proceedings. The first part of this series, we talked about why a patent owner who is faced with one of these PGR or IPR challenges and believes improving or changing the claims would help their position would not want to do a motion to amend in the IPR PGR and might look to one of these other tools. And we talked a bit about the differences in the reissue and reexamination proceedings and pros and cons and why you might want to pick one or the other. And here for part two, we're going to be assuming a patent owner believes it needs to make changes to the claims to improve its position and has selected reissue as the tool they want to use. And we're going to dig in a little deeper into reissue and some of the mechanics and strategic considerations and some of the nuances once a patent owner has made that choice and wants to go down the reissue road. First, let's talk about reissue application and the mechanics of filing it by a patent owner involved in a IPR proceeding.
I can start us off here by revisiting a little bit about the reissue and what the requirements are for reissue filing and timing of filing that reissue application in the context of a parallel proceeding like an IPR or a PGR. Revisiting old ground a little bit here, but remember that reissue is a tool that you can use as a patent owner to correct a variety of different errors in the issued patent, correct specification errors, errors in inventorship, perfecting priority. What we're talking about here is correcting errors in the claims. And so you can correct an error of claiming more than you had a right to claim in the original patent, narrowing those claims in reissue, or less than you had a right to claim in the original patent by broadening within a 2-year limit on the broadening.
From issuance of the patent?
2 years issuance of the patent. Absolutely. Yes. The timing is really important on that. And I would say that the very first thing that patent holders should do who are considering these procedures and what Mike and I, when we counsel clients and they're thinking about reissue in general, in any context, one of the first things we do is we look at that issue date. Really, our automatic is to say, are we within 2 years? Let's present an opportunity for broadening those claims, presenting a new claim that has broader subject matter within that 2 years. So that's the first thought on timing that we have is really, are we within that 2 years? And then really timing in connection with the parallel proceeding at the PTAB, you got to be careful about your timing there as well. If all of your claims are challenged in that IPR, PGR proceeding, you need to file a reissue application or a reexam, which we'll talk about in our next series here. You need to file it before the USPTO would issue a certificate that cancels all the claims of a patent. You need to get your reissue application on file before that happens. If all of your claims are challenged, you really want to have that timing in the back of your mind in case the IPR or the PGR goes south. Or if it's appealed, you need to do that before the Federal Circuit issues a mandate in relation to their decision that finds all the claims invalid or unpatentable. So that timing really needs to be closely monitored by patent owner when they're in those types of proceedings.
And, the PTAB does help you a little bit because I've noticed in final written decisions, there's always a little footnote at the bottom.
Yeah.
Saying reissue or reexaminations. They're sort of giving you a hint that if you want to do that, you got to do it certain timing. So they actually tell you expressly in there.
Yeah. Don't forget.
That's awfully nice of them, don't you think?
Sure.
Yes, very nice. Now, I'm thinking with a reissue, there's a couple of ways you might want to use it. You might say, hey, I've got this IPR. I'm going to let it keep going. I'm going to keep that fight going, but I'm going to file a reissue and kind of have them go in parallel. I've also seen these instances where folks take an adverse judgment in IPR and then they file a reissue. Let's talk about those two things. Maybe we'll talk about the first one initially, which is you intend to keep the IPR going, but you're going to file a reissue. How does that work?
First of all, back to our timing, it makes a lot of sense when you're facing that 2-year time period, that 2-year window is closing. You want to get your reissue application on file, even if you don't prosecute it right away. You want to get that reissue application on file within the 2 years to put your stake in the ground and to alert the public that, hey, we're going to seek a broadening reissue of this patent, and you let the proceedings proceed in parallel. There are stays possible. There are suspensions possible in your reissue proceeding or for your reissue proceeding when you have a parallel IPR or PGR, and you're going to let them both remain pending. You're going to let the IPR proceed or PGR proceed. We're not going to get into the details of those. It's a very complex topic that we could spend another whole series of podcasts talking about stays and suspensions and how they're requested or how you move for those and how they're lifted.
I know there's a statutory provision on it. So if you file a reissue and you have an IPR, say, and you're going to keep the IPR going, this question about whether or not to stay is something the Patent Office is going to address. They're going to decide whether or not to stay one of those procedures, right?
Yes.
So just before we move beyond the stay issue, Megan, I take it you have an IPR proceeding, you file a reissue. Oftentimes I've seen that either petitioner or patent owner might make a motion to stay, right? Why would one or the other make those choices?
If you're the patent owner, and let's say that you are within your 2-year from issuance time period for the patent, your timing is obviously very important for filing that reissue application and for telling the patent office and the public that you plan to broaden that patent via reissue. You're going to file your reissue application within 2 years, but you don't want to prosecute it right away. You want to see how the IPR or the PGR turns out. You think you have a good position, but you wanted your reissue application on file for broadening purposes within the 2 years. You could file that application and then turn back to your PTAB proceeding and make a motion to stay that reissue.
Sure. And then I imagine in some instances, a petitioner might say, well, they filed this reissue. Maybe it's a narrowing issue in that instance. And the petitioner doesn't want the two going in parallel. So they might make a stay motion, right?
Absolutely. They might make a motion to stay in that context, even if the patent owner tries to resist and really wants to push through a narrowing reissue in parallel with the proceeding, or maybe even try and beat the final judgment of the proceeding, whether appealed or not. They might try to do that as well and resist the motion to stay.
Going back to the patent holder wanting to stay, even just if it's filing for a broad and reissue. I mean, we talked in the prior embodiment of this podcast about the duty of candor reattaching. And might that be a reason as well to move to stay, just because you don't want to have to deal with having to decide what to disclose in the adversarial proceeding to the central reexamination unit that decides the reissue? So that would yet be another motivator to perhaps have a stay so we don't have to deal with that headache.
Yeah, absolutely.
And then will the patent office sometimes on its own decide to stay one or the other, even if no motion is filed?
Yes, the patent office can act on their own. They can act sua sponte to suspend the reissue application while the AIA proceeding is going.
Let's go back to this topic of filing the reissue and the IPR and not taking adverse judgment. So intending both to be procedures that will go forward. Separate from the stay issue, what other considerations come into play in that scenario where you're not taking adverse judgment in the IPR?
It's a good question, Andy. And I think that really it's an iron in the fire, right? You're giving yourself an opportunity to amend your claims in a procedure that is more conducive to amending your claims than in a motion to amend during the IPR or the PGR proceeding. You're also putting yourself in a position to have a timely filed reissue application to provide yourself a fallback, frankly, if things don't go well in the IPR PGR proceeding and you end up with a final written decision that results in cancellation of claims, and you really want to have an avenue to revive or rehabilitate that patent.
Within the 2 years from issuance of the patent, the broadening concept is a convenient way to have your cake and eat it, where you've given yourself a chance to go into reissue without necessarily at that point presenting claims to narrow up the ones that are in the issued patent. So it really just provides you a vehicle without potentially showing your hand that you're worried about the pending claims. And in fact, maybe creating some anxiety for the patent challenger because, oh, not only, do I think my claims are good, but here we're going to go out for broader ones that maybe will make things even worse for you. Maybe that's the way to look at it. Of course, if that doesn't afford itself, you've got a patent that's over 2 years from issuance. Well, that's not going to provide you the convenient way to hedge your bets about something going adversely in the IPR proceeding. So then you would, as I think we've talked about before, go to hedge claims as a convenient way to basically get yourself into the other proceeding, a proceeding that's more hospitable to amending, and just basically have your place in line reserved in the case
Because
that the IPR goes badly.
right, because I guess, correct me if I'm wrong, but if you keep the IPR going, you fight that fight as a patent owner, maybe you win, and that's great. But if you don't, you've got this reissue there, whether it's broadening or narrowing, it's like a backup position, right? And you've got it filed in there. And so you're giving yourself, as a patent owner, multiple opportunities to prevail, i.e., have claims survive the attack. Either you get amended claims and a reissue, or maybe you beat the IPR.
That's the reason you'd want to keep both pending. That would be the scenario of keeping both pending. And perhaps the way you do it is, you just go ahead and file your reissue application with either the hedge claims or the broadened claims, depending on what your degrees of freedom are. And maybe you're happy to just put the brakes on it at that point as the patent holder and let it sit, because you've kind of accomplished what you want. You've got the tool to amend in a more hospitable forum. And on the other hand, wait and see what happens in the IPR before you move it forward. And if, in fact, the IPR goes well for you, you might, if you don't really think you got anything to broaden and you're not really all that excited about head claims, you could drop the whole thing and just say you're going to abandon the reissue application and life goes on. But on the other hand, if things go badly in the IPR, you've got the tool ready and waiting for you to use, i.e. reissue.
And I suppose because the reissue is available after a final written decision, as long as you appealed it, no mandate or before the certificate, wouldn't there be some benefit to seeing that final written decision and seeing what the board did with, for example, art cited and what they said? Because that could help you craft, for example, narrower claims in a reissue. Is that something you think about?
Absolutely. I think you have to think about it. You're going to have to show the patent office you thought about it. So I think that it's absolutely a useful tool. And some folks wouldn't file their reissue until after they receive that final written decision. They have it in their mind that they're going to file a reissue application, but they don't do it at the outset. The early stage timing is typically after you get an institution decision, or maybe based on the strength of the petition grounds, that you're going to want to think about narrowing your claims or having a tool to use to amend your claims. So maybe you do it early stage, like we've been talking about. Maybe you do it late stage. Maybe you get the final written decision. You see how things shook out and you say, I could really improve the claims in a reissue application, and you get it on file before that trial certificate comes down, canceling all the claims.
And theoretically, you could do both, right? Because you could file a reissue before the final written decision and then file a continuation reissue after. Is that right?
Yeah, you can. We keep talking about broadening because it's so important. Really, it's so important if you're within that 2 years to get that reissue application on file to give you an opportunity to broaden aspects of the claim that you're able to broaden. Maybe you're going to narrow something up to address the grounds of the IPR, and you could broaden in another way that makes that claim really commercially valuable. So that's really important. And if you get that on file within the 2 years, you can file broadening continuation reissue applications. I mean, how great is
after the
that?
2 years at that
Right.
point.
Yeah.
Yes, absolutely. It's a huge opportunity for a patent holder if they're within that 2 years when they file that first reissue application. So you're right. You can, after the final written decision, take stock of what is there, take stock of your reissue application that maybe you already have on file. And then maybe you're right, file a continuation reissue application to cover some varying scope that would be helpful to you.
Or you could just file an amendment to your reissue that's already pending to present whatever else you want to go forward with. You could do it any of those ways.
Sounds like there's a lot of flexibility.
That's the name of the game of the reissue.
That's right. Let's talk about the other scenario, because I've seen these instances where a patent owner takes adverse judgment in IPR and then files a reissue, or might file the reissue just before. What are some of the scenarios where a patent owner might decide to go down that road?
I think there's a few different considerations when folks think about taking adverse judgment. First, the strength of the petition grounds. You may be facing down the barrel of what you know is a very difficult and expensive proceeding at the PTAB. And you see reissue as an opportunity to make some clean amendments that would address those grounds. I think that's absolutely a consideration once you see the strength of the petition grounds, or after the institution decision is made and the strength of those grounds are signaled by the PTAB in the institution decision. I think that another big consideration, and I mentioned it already, is expense. If there's uncertainty around your chances of prevailing in the patent office trial, I think that that is a serious consideration for a patent holder where expense is a significant issue.
I've also seen instances where, say, a district court has rendered an unfavorable 101 decision on a patent. Is that another scenario where you might say, well, there's already a bad 101 decision. I've got this prior art challenge in the IPR, and because you could firm up the claims on 101 also, or try to, in a reissue, right?
Absolutely, you can. That is a big consideration when that factor's at play.
So say you go down this adverse judgment route. I know there's some things you have to be careful about because you got to present claims in the reissue that are sufficiently different, right, from what you're surrendering when you take adverse judgment. Maybe talk a little bit about how all that works.
Yeah, and that's exactly, you phrased it really well there, that you are considered to surrender that subject matter, really. And you have to show to the patent office that you're presenting narrower claims, patently distinct claims that avoid that surrendered subject matter. It can come in a couple of different forms. If all of the claims were challenged of your patent and they all wind up canceled as a result of the adverse judgment and the trial certificate that results from that, then if you filed your reissue application timely, you will be given an opportunity to show the patent office that you are willing to abide by the surrender of that subject matter, that you are presenting narrower claims, and that those claims are patentable over those claims that were lost as a result of the proceeding and the adverse judgment. And that can be a little nerve-wracking to be on the receiving end of the form in which it comes, which is an order to show cause by the patent office. So the patent office will give you an order to show cause and say, prove it up. Show me how your claims are narrow and patentably distinct of those that were lost.
Is that a communication with the patent office that comes early on after you file the reissue and before they actually start up examination, they order to show cause?
Yeah, it can depend. It can be case to case when it arrives. But typically in the scenario that we're talking about, you've requested adverse judgment and you've gone into the patent office and you've previously filed your reissue application. The timing will likely be that you're doing it early on in the reissue application process, and that order to show cause is going to come early on before examination begins, just by the natural timing of requesting adverse judgment and filing your reissue application.
Perhaps either in tandem or just before you request adverse judgment, submit an amendment to beyond whatever you did to start the reissue, which presumably was perhaps more innocuous. Or maybe that is a starting round. These claims aren't valid. But it would seem to me it'd be best to go ahead and say you're going to present claims of intermediate scope as your opening volley to have the reissue there. And then after you have a serial number and everything else, file an amendment that says either I just filed for adverse judgment or there's error because these claims that are already in the original patent have an error because they claimed too much, or however you want to say it. And then you proceed with your amendment right then. So at least just have everything in there as far as what you're planning to do before there's an adverse judgment. And then if they go ahead and ask you to show cause, well, you're ready to go because everything's in there already. And that's the reason I really want to proceed with this reissue, is to show you that these claims that we are now presenting are patentable over whatever was used to say the originals were no longer patentable.
What advice can you give about how much you say or don't say about the error in the original reissue application? Because in this context where we're in a PGR or IPR, I imagine that's something you want to be careful about.
Yeah, I think we've hit on this before, right? Typically, you want to say as little as possible.
You want to say enough that they'll take up the reissue.
Yeah.
It's not like a fall on your sword scenario.
Yes. And I think that it's different if you're in the context of a broadening, because you could still, if you're within the 2 years, broaden and really thread the needle on all of this and broaden your claims while also addressing whatever issues were presented in the trial. But it depends on whether you're broadening or narrowing, because the requirements are different for the type of error that you need to present to the patent office. If you're narrowing your claims, it could be the matter of checking a box and just saying that you claimed more than you had a right to claim and narrowing your claims accordingly. You can also, like Mike said, at your initial volley to get the reissue application on file, maybe you want to just present some hedge claims and some dependent claims, claims of intermediate scope, and detail your error in that way, that you failed to protect your invention by the full extent allowed by the law and failing to present those dependent claims. If you're broadening your claims, though, you have to detail the way in which you're broadening your claims. So that is a little bit trickier because you need to really flesh that out in one way, at least one error in the body of your error statement to the patent office.
So the fact that you have other errors, i.e. your original claims aren't patentable, you can remain silent on that by
Yes.
focusing on these more innocuous things. You don't have to identify every error, just need to identify one.
So let's assume we file the reissue, and whether it's adverse judgment or you're keeping the IPR going and you overcome the order to show cause. Is it then like normal prosecution, like you're back in prosecuting a case? Is it different? Once you're over those hurdles, how is it different? And is the timing like normal prosecution, or is it longer, shorter?
Yes, it is similar to regular prosecution, with the exception that you're living with the patent owner estoppel that came from requesting adverse judgment, or, assuming your IPR didn't go your way, that you're living with the result of that proceeding if it was adverse to you as a patent owner. So that adds an extra nuance. But it is like regular prosecution. You get full examination of those claims. It's in front of the central re-exam unit, which is different than regular prosecution being in front of the examiner and the examining court. And these are specialized examiners that handle reissue and re-examination proceedings. And although it's like regular prosecution, it is a little bit faster. They're handled and they're treated in a manner that puts these reissue applications in a special position in the docket to proceed more quickly through the docket than other cases.
We talked about this a little bit in part one of this series, but maybe it's good to just mention again, you're in the reissue, overcome the artificial cause, you go through the prosecution, you got allowed claims. What happens then, and how would that impact an IPR proceeding, or how is that different from reexamination and coming out with claims in a reexam?
In the reissue context, it's a little bit similar to regular prosecution in this way. You get a notice of allowance, you have allowed subject matter, you pay your issue fee, and you get a new reissued patent. You get a brand new patent that reissues the original patent. So the original patent then becomes surrendered upon issuance of the reissued patent. Important to our discussion here when you're considering whether or not to pursue a reissue or a reexamination in order to amend your claims, either in parallel with or as an off-ramp to an IPR or PGR proceeding, the new reissued patent, it's a new patent subject to a new estoppel under Section 315B. So the 1-year time period from which an infringer or an alleged infringer has from service of a complaint to filing an IPR proceeding, it will be affected by that. It's a new patent that's not subject to any original estoppel.
It's a new patent, so for petitioners in an IPR or PGR, they get a whole new shot without any time.
That's exactly right.
And this probably goes without saying, but the reissue patent is still subject to the same term. I mean, you don't get any extra term with a reissue patent.
It is for the term of the original patent.
Well, any other closing thoughts on strategies or mechanics if a patent owner has chosen reissue as its mechanism to make changes to the claims in the context of a IPR PGR?
Absolutely. I think reissue is an incredibly flexible tool that patent owners can think about using when they're faced with an IPR or a PGR. You always want to be thinking about the tools that you can use to your advantage to amend claims. And reissue presents a really flexible tool to use. The other tool is reexam. And that's been highlighted by the USPTO via their 2019 notice. And we're going to talk a little bit more about the mechanics of reexam in our next podcast.
And in fact, both proceedings before the central reexamination unit are generally far more favorable to amending than in the PTAP proceeding.
Well, thanks, Mike and Meg, for talking about reissue and the options and strategies for that. For part 3 of this series, we'll get into the mechanics of reexam in the context of an IPR or PGR proceeding. In the meantime, Troutman Pepper's intellectual property team will continue helping its clients develop and implement global protection and commercialization strategies for intellectual property. For more information on how we can help with intellectual property issues, feel free to visit our website, troutman.com. You can also subscribe and listen to other Troutman Pepper podcasts wherever you listen to podcasts, including on Apple, Google, and Spotify. Thank you.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.